Express trusts. Under the common law. A superior and distinct mode of administration. Distinguished from partnerships. Contrasted with corporations. 2 papers submitted to the Tax Commissioner of Massachusetts, under Chapter 55 of the Resolves of 1911, requiring a report from him on voluntary associations. By Alfred D. Chandler, Esq. Of the Boston Bar. Boston Little, Brown & Co. 1912. Z, RG, 1J. At, 13. /I_13O and LT /. Copyright, 1912 BV Alfred D. Chandler. The Riverdale Press, Brookline, Massachusetts, USA. By Chapter 55, Resolves of 1911, the Tax Commissioner of Massachusetts was directed to make an investigation of voluntary associations organized or doing business in that Commonwealth under a written instrument or declaration of trust, the beneficial interest under which is divided into transferable certificates of participation or shares, with a view to determining the present legal status of such voluntary associations and whether or not their prohibition or further control and regulation by that Commonwealth is advisable and in the public interest. The resolve is as follows. Chapter 55. Resolve to provide for an investigation of voluntary associations organized or doing business in this Commonwealth under written instruments or declarations of trust. Resolved, that the Tax Commissioner is hereby authorized and directed to make an investigation of voluntary associations organized or doing business in this Commonwealth under a written instrument or declaration of trust, the beneficial interest under which is divided into transferable certificates of participation or shares, with a view to determining the present legal status of such voluntary associations, and whether or not their prohibition or further control and regulation by the Commonwealth is advisable and in the public interest. The Attorney General is hereby directed to give the Tax Commissioner such assistance as the latter may desire in making this investigation, and said Commissioner may, if he deems it advisable, hold public hearings, after due notice, and shall consult with the Board of Railroad Commissioners and the Board of Gas and Electric Light Commissioners with a special reference to the effect of such voluntary associations upon the supervision and regulation of gas, electric light, and street railway companies in this Commonwealth. The Tax Commissioner shall report the result of his investigation to the General Court on or before the second Saturday of January, 1912, with such recommendations as he may deem advisable, and he shall submit, with his report, drafts of any bill or bills necessary to carry into effect any recommendation which he may make. In conducting the above investigation, the Tax Commissioner may employ such assistance and incur such reasonable expenses, not exceeding $2,500, as may be approved by the Governor and Council, and said Commissioner shall have power to require the attendance and testimony of witnesses and the production of all books and documents relating to any matter within the scope of the said investigation. Witnesses shall be summoned in the same manner and be paid the same fees as are witnesses in the Municipal Court of the City of Boston. Approved April 15, 1911. Citations. Page Ames Cases on Trusts. 33 Bank of Topeka v. Eden. 100 Federal Republic 8. 32, 33 Black's Constitutional Law. 10 Broadway NAT Bank v. Wood, 165 Massachusetts 312. 33 Brown v. Eastern Slate Co., 134 Massachusetts 590. 33 Cooley's Constitutional Limitations. 34 Cox v. Hickman, 9 CBNS 47, 8 H of L Cases 268. 28, 29, 30 Elliott v. Freeman, 220 U.S. 178. 13, 26 Everett v. Drew, 129 Massachusetts 150. 28, 31. Farmers Loan and Trust Co. v. Chicago, etc., 27 Federal Republic 146 9 Federal Constitution, Art. 4, Sector 2. 9 Federal Statutes, Annotated, Volume 9, pages 178 to 9. 9 George on Partnership. 30 Gilmore on Partnership. 30 Gleason v. McKay, 134 Massachusetts 419, 17, 18, 19, 23, 28, 29, 34 Governor Fernald of Maine. 1 Hamilton's, Alexander, Works. 6, 23 Hewitt v. Phelps, 105 U.S. 393. 33 Hussey v. Arnold, 185 Massachusetts 202. 32 Johnson v. Lewis, 6 Federal Republic 27. 19, 28, 29 Lackett v. Rumbaugh, 45 Federal Republic 23. 19, 27 Law Quarterly Review, October, 1905, p. 365. 18 Mason v. Pomeroy, 151 Massachusetts 164, 7 LRA 771. 19, 28, 29, 33 Massachusetts Business Corporations, Hall. 18 Mayo v. Moritz, 151 Massachusetts 481. 19, 28, 29, 31, 33 Miller v. Simpson, 107 VA 476, 18 LRA, NS, 963, note. 30 Minot. Winthrop 162 Mass. Point 113. 34 Norton v. Phelps, 54 Miss 467. 33 Oddfellows Hall Association v. McAllister, 153 Mass. 292. 33 O'Keefe v. Somerville, 190 Massachusetts 110. 17. Opinion of the Justices, 196 Massachusetts 603. 17, 18, 23, 34 Page on Contracts. 32 Parsons on Contracts. 32 Parsons on Partnership. 15, 27, 33 Paul v. Virginia, 8 Wall. 168. 9 Perry on Trusts. 9, 32 Phillips v. Blatchford, 137 Massachusetts 510. 20, 28, 29. Ricker v. American Load and Trust Co., 140 Massachusetts 346. 26 Robbie v. Smith, 1311 ND. 342, 15 LRA 792. 9 Shirk v. City of Lafayette, 52 Federal Republic 857. 9 Shoemaker's Law of Partnership. 30 Simmons, Mr. J. Edward, Banker. 20 Smith v. Anderson, LR 15, CHD 247. 19, 27, 28 Spotswood v. Morris, 12 Idaho, 360, 6 LRA, NS. 665, 16 Stories Equity. 33. Taft v. Ward, 106 Massachusetts 518. 20 Taylor v. Davis, 110 U.S. 330. 19, 27, 31 Trustees Handbook, Loring. 32. Underhill on Trusts. 9, 33 Walds Pollock on Contracts. 22, 26 Warner v. Beers, 23 Wendell, 103, 18, 22, 23, 32 Wellstone Mercantile Co. v. Grover, 7 ND 460, 41 LRA 252. 27, 28, 29, 32, 33 Verner on Administration. 31 W. Ison, The Honorable Woodrow. 5, 6, 20, 35. Express Trusts. Corporations. Voluntary Associations. First paper, November 20, 1911. The Honorable Woodrow Wilson, in his cogent address entitled The Lawyer and the Community, before the American Bar Association, at Chattanooga, Tennessee, August 31, 1910, transmitted later in pamphlet form, challenged the profession in demanding that the impersonal feature of corporations should be restricted as the one obstacle that has blocked progress toward effective corporation reform. This question, he says, stands in the foreground of all modern economic questions so far as the United States is concerned. Liberty is always personal, never aggregate, always a thing inhering in individuals taken singly, never in groups or corporations or communities. The individual unit of society is the individual. That is why I plead so earnestly for the individualization of responsibility within the corporation, for the establishment of the principle of law that a man has no more right to do a wrong as a member of a corporation than as an individual. Mr. Wilson was promptly advised from Boston that his call upon the profession had been anticipated in Massachusetts by numerous express trusts declared in that state, and which exercise the common law natural right to employ all the mere incidents or accessories used in the management or mobility of property, such as transferable shares, bond issues, promissory notes etc., but which do not and need not arrogate any essential of a corporation, such as merging natural persons into an impersonal, artificial entity, or suing or being sued under their designated name, and which, with proper provision for reimbursement, place upon trustees a personal responsibility that corporate laws 6. Are especially designed to evade, and which evasion, legalized by state legislatures, both confirms the popularity and causes the condemnation of corporations. Mr. Wilson was referred to, among others, the example furnished a century ago by Alexander Hamilton, who employed this trust method in use long before his day in organizing the Merchants Bank of New York, and he was further reminded that some corporation promoters might discourage this effective personal bulwark, and that states like Maine and New Jersey, that have coined money by marketing corporation charters created on the impersonal basis, might frown upon this sound, independent, common law trust method of administration. Mr. Wilson promptly expressed his sincere appreciation of the information that had called his attention to a most interesting matter which he wished more carefully to look into after the distractions of the present campaign are over. In guarding the state and the business world from the pitfalls of impersonal corporate bodies, both the bar and the bench should encourage the application to affairs of the elastic, effective, and well-grounded principles of common law express trusts. Mr. Wilson, in his Chattanooga address, insisted that although corporations must continue to be used as a convenience in the transaction of business, yet they must cease to be used as a cover to wrongdoers. And he added, it is the duty of lawyers, of all lawyers, to assist the makers of law and the reformers of abuses by pointing out the best and most effective way to make it. Express trusts, which now meet with augmented approval in Massachusetts, and the merits of which the country at large begins to appreciate, put the legal estate 7. Entirely in one or more, while others have a beneficial interest in and out of the same, but are neither partners nor agents. This simple, adequate, common law right, any person or group of persons sui juris may exercise, the trustees issuing certificates of beneficial interest divided into shares, as well as issuing bonds and other obligations, as freely as they open a bank account, have a passbook, and draw and circulate checks, or make whatever contractual relations are allowed to persons as a natural right. Express trusts have been in successful operation in Great Britain and America for generations. They have been and are applied wisely in both hemispheres to property valued at hundreds of millions of dollars. To affirm at the state that considerations of public policy do not countenance express trusts that utilize conventional business accessories is to challenge sound economics. Public policy is not always immutable. Neither lawyers nor laymen can ignore experience or the truth. It was Coleridge who wrote that a man who squares his conscience by the law was a common paraphrase or synonym of a wretch without any conscience at all. If public policy in this instance is to be measured as it should be by a standard of stability rather than of instability, the startling contrast presented later between express trusts and Massachusetts corporations ought to modify some notions of public policy. It is the substantiality of the trust principle, based upon personal responsibility and efficiency, that has so commended it over loose, evasive corporation laws found from the Atlantic to the Pacific. Well-drawn modern express trusts avoid no legal obligation, much less do they evade any. If perverted, they should of course be restrained. They avoid needless business obstacles, they require no arbitrary fixed capitalization, they can dispense with the deceptive fiction of a par value, a fiction that the New York State Bar Association is reported to have induced as a tool of many rascals. 8. And the honest servant of no man, they promote sound administration, they stimulate mercantile intercourse, and they secure a higher standard of efficiency through active trustees than is generally attained through the usual perfunctory, often irresponsible, dummy, corporate directors who fail to direct, and who when called to account in court are admonished that the high criterion of a trusteeship should be their canon of conduct rather than that of a shifty directorate. Trustees under express trusts pay taxes on their real and personal property. Trustees have to report fully to their beneficiaries, or be called to account in court by them. Publicity, as with partnerships, is secured to all who are entitled to it. Public curiosity, mere prying, or prurient curiosity is not gratified, and ought not to be. The trustees are protected, as they should be, from personal loss, by a provision for exoneration or reimbursement from the estate, except in case of willful default or of fraud. The customary provision in the declaration of trust requiring all parties who deal with the trustees to look to the estate for ultimate security, rather than to the trustees or to the beneficiaries, conforms with a common law principle long sanctioned. Such a provision is a strong assurance of the merits of the trust, because if its foundation does not permit of a substantial superstructure, as the basis of credit, the trust is not likely to be declared or to induce desirable trustees to accept it. Corporations on the other hand offer a premium, as it were, for a weak foundation based upon an irresponsible artificiality, and hence go to the wall by the thousands. Express trusts, under the common law, regulated by equitable principles and practice, furnish some of the highest models for administration. Corporations under state laws invite and are responsible for the greatest business scandals in our history. One who prefers to drink from a pure spring on a common cannot justly be charged. 9. With evading a nearby licensed barroom. The latter may often be wisely avoided. As for the equitable laws that regulate trusts and trustees, they are a well-formed system which Mr. Justice Story pronounced as even more symmetrical in the United States than the original system in England. Mr. Perry, one of America's leading authorities upon trusts, affirms that every kind of valuable property, both real and personal, that can be assigned at law may be the subject matter of a trust. And further, the person who creates the trust may mold it into whatever form he pleases. Perry on Trusts, I. 67, 287, Underhill on Trusts, p. 57, America ed. The federal Constitution protects trustees as citizens throughout continental United States, but corporations, not being citizens as that word is used in the Constitution, do not have the privileges and immunities of citizens. Corporations cannot enter another state except on the terms which that state prescribes. But trustees under a will, or under an express declaration of trust, are natural persons and are citizens in the fullest sense under the Constitution, and, as natural persons possessed of both state and national citizenship, are entitled to all the privileges and immunities of the citizens in the several states. Federal Con. Art. 4 Sector 2. Farmers Loan and Trust Co. v. Chicago, etc., 27 Federal Republic 146, 149. Shirk v. City of Lafayette, 52 Federal Republic 857. Robbie v. Smith, 131 IND 342, 345-6, 15 LRA 792, 794-5. 9 Federal Statutes Anot, pages 178-9. Mr. Justice Field of the Supreme Court of the U.S., in his opinion in the famous case of Paul v. Virginia, 8 Wallace, 168, 180, wrote, "It has been justly said that no provision in the Constitution has tended so strongly to constitute the citizens of the United States one people as this." 10. The purpose for which this clause was inserted in the Constitution was to prevent the states from making invidious discrimination against non-residents, and to promote the unification of the American people, by breaking down state lines, in respect to the enjoyment of social and business privileges and the favor and protection of the laws. Black's Constant Law, p. 292. In most cases businessmen do not need a corporate charter, except for railroads, for the right of eminent domain, for banks, for insurance, and for certain public service functions. In most cases the state gives no adequate equivalent for its charter. It is often a useless encumbrance, and it often stimulates mercantile iniquity. Our corporation laws throughout this country have become such a legalized means of evasion because of the impersonality, the artificial entity which they sanction, that they have elicited caustic criticism from executives, economists, educators, and businessmen. In conservative Massachusetts over 4,154, of its state corporate charters, representing many millions of dollars of authorized capital stock, were dissolved by its legislature in the last 5 years, an average of over 2 a day, omitting those otherwise dissolved. This shows that even Massachusetts conservative corporation laws are a delusive will-o'-the-wisp to thousands of impressionable, misdirected people. This state incorporates about 1,200 or 1,300 companies a year, making for the past 5 years from about 6,000 to 6,500, and over 4,000 or about 64% were dissolved in that time. A very large number of Massachusetts corporations appear to be mere fugitive organizations, based upon credulity, and to be plucked in transit. This state cannot in justice demand the application of such an administrative system to every enterprise. It cannot properly insist upon a uniform, undiscriminating, and often inferior business method, whether for industrial or 11. Taxation purposes, and then as an excuse say that it is not its function to join in the futile attempt to save the foolish from the consequences of their folly. The state's corporation record in a large part on this score is self-incriminating. Here it is condensed, the list covering about 94 pages of the state laws, Massachusetts. Corporations dissolved. In the last 5 years. Acts of 1907, ch 290, pages 226, 250, 1909, ch 347, pages 296, 324, 1910, ch 609, pages 662, 684, 1911, ch 363, pages 331 to 351 number dissolved 1164 1185 932 873 4154. Contrast the above excessive corporate mortality with the remarkable vitality of express trusts as furnished by the lists of real estate trusts in Boston, published by Burroughs and Debois*, the first of which appeared in 1899, and contains 17 such trusts, every one of which are found today, with many more, on the monthly list which that firm publishes, and which list now represents investments of about $110 million. We do not know the whole number of real estate and of industrial common law trusts, as well as partnerships, that make use of transferable shares, and are now operating in Massachusetts and elsewhere. But express trusts under testamentary and other written instruments affecting interests large and small, as well as partnerships, number many thousands. Some states openly depend upon the liberality of their corporate charters to pay their expenses and to cancel their debts. Such a course is condemnatory. Sound finance repudiates it. * Real Estate Trust Stocks, 30 Kilby Street, Boston. 12. Governor Fernald of Maine, in his address to the legislature of that state in 1909, while suggesting reform in its corporate laws, stigmatized his state thus. While it is true that the state are receiving large revenue from this source, it is also true that, in a considerable measure, it is the price of prostitution. Hope you will take steps to remodel them, along evident lines of reform, thus restoring to Maine her SLF respect. Severer strictures than this can be produced from recognized authorities in this country, as to the dishonor of corporate legislation, and as to the iniquities of impersonal and non-moral corporate body acts that would expose individual trustees under express trusts to personal liability. While relatively the good wrought by corporations has been very great, yet absolutely the volume of mischief they are responsible for, and continue to invite, has been, and is enormous. Nowadays the right to organize a corporation is almost as free as the right to execute a deed of real estate. It has been carried to the utmost irresponsibility, and one may order and may receive, through the medium of charter purveyors, a number of corporate charters representing millions of capital, from any chosen state, almost with the seal righty that one may order and receive as many boxes of cigars. Ordinary conveyancing, or constructive legal drafting, are utterly outmatched in such a performance. The proper initial deliberation and after responsibility and attention that are respectively a condition precedent to the formation and condition subsequent to the acceptance and performance of a meritorious express trust, proffer a wholesome corrective to the rash multiplication of the many anemic, moribund corporations that Massachusetts improvidently creates, feels bound to nurse for a while, and is then compelled to bury by the thousands. Our next state commission might well be one on corporation eugenics. 13. Long before it was given, the decision of the Supreme Court of the United States last winter in Elliott v. Freeman, 220 U.S. Republic, p. 178, holding that express trusts in vogue in Massachusetts and elsewhere are a_s free as partnerships from the application of the federal tax on doing business under a corporate charter, had been anticipated and acted upon accordingly in Massachusetts. That decision has a wider significance than may be realized in the transcontinental scope of its salutary application. A few strong, permanent express trusts are worth more to the state and to the United States than the entire 4,000 chartered Massachusetts corporations cast by the wholesale into oblivion in the last 5 years by their own progenitor. The Massachusetts legislature passed a Resolves of 1911, Chap 55, to provide that the tax commissioner shall make an investigation of voluntary associations organized or doing business in this Commonwealth under a written instrument or declaration of trust, the beneficial interest under which is divided into transferable certificates of participation or shares, with a view to determining the present legal status of such voluntary associations, and whether or not their prohibition or further control and regulation by the Commonwealth is advisable and in the public interests. The tax commissioner was to report on this on or before January 13, 1912 *. If such an inquiry is aimed at one or two exceptional organizations affecting certain public service utilities, the public should be frankly informed thereof. But if its object is to put every personal express trust, and every partnership, that makes use of transferable shares, on a level with impersonal corporations, and to prohibit, or even to sub***. His report is dated January 17, 1912, and found in House Document number 1646. 14. Checked every such express trust, and every such partnership, to an inquisitorial state control, though they are not created by the state, and are not all clothed with a public interest, then its purpose assumes a scope that requires extreme caution on the part of the legislature. Put in syllogistic form, the prohibition aim of this inquiry involves the following fallacy: some voluntary associations have been holding comp-aims. Some holding companies are said to have done harm. Therefore public policy demands that hereafter all voluntary associations shall be prohibited. The irrationality of the above will be more apparent if the syllogism is paraphrased thus: some lawyers have been presidents of the United States. Some presidents are said to have done harm. Therefore public policy demands that hereafter all lawyers shall be prohibited. This inquiry is directed to so-called voluntary associations. Can anyone satisfactorily define, or explain the origin of, or justify the retention of that indefinite expression, voluntary association? Is its antithesis, an involuntary association, ever used, either colloquially or technically? The difference between creation by sovereign power and creation by private contract is not a sufficient basis for the term. The creation in both cases rests upon volition. The sovereign does not force citizens to create. Organization is optional under the general corporation laws. The term, however old, has no fixed application. It is not analogous to a voluntary settlement or conveyance which depends upon a meritorious or natural rather than a valuable consideration, upon blood or affection or 15. Liberality than upon a compensatory or material advantage. The definition of a voluntary association as given in the Century Dictionary is a society which is unincorporated, but is not a partnership, in that the members are not agents for one another. The word voluntary adds nothing definite to the word association. The word association is understood to mean a body of persons united without a charter. Associations are sometimes partnerships, and oftentimes not partnerships. The true test of partnership is the intention of the parties. Parsons on part. 54. Associations to produce something and divide the product are not partnerships. ID 61 as to work a gold mine and divide the gold, to make and divide bricks, to fish and divide the fish caught, to manufacture and divide lumber. ID 61 note, and 445, 446. Clubs and associations for social or charitable purposes are not partnerships. ID 60. Colloquially, a voluntary association may be any group of persons, whether incorporated or not, from the United States Steel Company to a boys' baseball club, or a women's sewing circle, united of their own volition, and one and all will have a right to issue transferable certificates of participation or shares, without thereby affecting their legal status. The Lady Soldiers and Sailors Monument Association, 161 NY 353, or a Farmers Association to construct and operate a telephone line, 122 NYS 610, or the Washington Tent No. 1, Independent Order of Rechabites, Associated for Temperance, Sympathy, and Decent Funeral Obsequies, 81 NY 507, none of which were held to be partnerships, might any or all have been organized to use transferable shares, as well as the New England Gas and Coke Co. and the New England Investment and Security Co., 198 Massachusetts 413, 425, 430, b. 16. Latter two representing many millions of dollars of capital, and all of the above may be, as they are, referred to as voluntary associations**. We have corporations, joint stock companies, common law and statutory, partnerships, trusts, meaning combinations of corporations, a modern perversion or restriction of the term trust, and now that an apposite, sweeping, indefinite designation voluntary association has become the subject of a legislative inquiry in Massachusetts, which if it results only in helping to drive that expression into disuse, will be beneficial. To attempt through legislation to synonymize or to put on a parity voluntary associations, partnerships, and express trusts created by private contract, and maintain that all three are like corporations created by the state, and to be regulated like corporations, merely because the common law right of issuing shares is exercised by any one or all of them, is to invite contention. And to maintain that because some questionable voluntary associations have overstepped the mark, that, therefore, all express trusts, and partnerships, and good voluntary associations, shall, without distinguishing between public utilities and private enterprises, be prohibited or controlled and regulated by the state, is fallacious and prejudicial. The confusion and the constitutional conflict such a course might incite recalls the swift disposition the writer made with the state authorities 30 years ago, in 1881. The definition given of voluntary association by the tax commissioner in his report House Document No. 1646, P2 is as follows. The term voluntary association as 11.NLA used S.I.L. NIF is an association of persons with a combined capital, represented by transferable shares, for the purpose of carrying, L, on a common project for, LALN. But this attempt to narrow the term by so restricting its scope is arbitrary. It seeks to accentuate the features of transferable shares and of gain. But there are innumerable so-called voluntary associations without transferable shares, and very many with such shares carried on without trading with third persons for gain. TC the leading case of Spotswood v. Morris, 12 Idaho, 360, 6 LRA, NS. 665, 1906. 17. Of the Act of 1878, Chap 275, to tax companies, co-partnerships and other associations, in which the beneficial interest is held in shares which are assignable, etc., which Act, not long after, received its judicial quietus as unconstitutional by the decision in Gleason v. McKay, 134 Massachusetts, 419, 1883, reaffirmed and given a new application in O'Keefe v. Somerville, 190 Massachusetts, 110, 1906, and discussed in the opinion of the Justices in 196 Massachusetts, 603. 1908. The supposition that transferable shares are a peculiar prerogative or special privilege or attribute of corporations, and that whoever uses them is to be disclaimed as copying an essential of a corporate state charter, or as availing of an important characteristic of corporations, is a mistake. Transferable shares are not an essential, not even an attribute, not an inseparable or distinguishing mark of any corporation, but a mere incident or accessory of some corporations. The corporations that represent the largest aggregate of capital, and whose total business now exceeds that of the nation itself, issue no shares. These are municipal corporations. So, too, transferability of shares is not essential to chartered colleges, academies, hospitals, and other corporate institutions, founded by public endowment or private beneficence. Nor are such shares necessary in many scientific and literary societies for mutual benefit or charity, in the funds of which the members have a beneficial interest. On the other hand, such a right of transfer may be incorporated into partnership articles or into testamentary or other express trusts, and become a fundamental condition of them, without altering their legal character, or trespassing upon any corporate attribute. Legislatures and even courts have occasionally fostered the above misconception, and courts have had to correct themselves thereon. Mistaken ideas as to transferable. 18. Shares, as well as to other mere incidents of corporations, were analyzed and exposed over 70 years ago in New York in the leading case of Warner v. Beers, 23 Wendell Reports, pages 103, 116, 130, 145 to 151, 174 to 176, 1840. Transferability of shares is recognized in Massachusetts as a natural right at common law. Gleason v. McKay, 134 Massachusetts, 419, 425, 1883. Opinion of the Justices, 196 Massachusetts 603, 627, 1908. It is to be hoped that here in Massachusetts no revival of the above-mentioned mistake will mislead either its executive, legislative, or judicial departments to believe that such an error can be justified either upon economic or upon legal grounds. Our free common law rights in that respect rest on too broad and sound a footing to be curtailed by an assumption so narrow and mistaken. The acquisition of a formal charter of incorporation only recognizes, but does not bestow, these rights. See the personality of the corporation and the state, in 21 Law Quarterly Review, p. 365, at p. 370, October, 1905. As for listing shares on stock exchanges, those exchanges have their own rigid rules of acceptance or rejection which form a public safeguard. The returns to the state required of corporations are not because a corporation issues transferable shares, but because the state is to keep information at hand of its own corporate creations, or, as Mr. Hall expresses it. The present law, passed in 1903, adopts the modern view that the state owes no duty to investors to look after the solvency of corporations, and that its sole obligation is to see that creditors and stockholders shall be at all times informed as to the organization and management of the corporations to which it gives franchises. Massachusetts Business Corp. Hall, p. 3, 2d ed. The present legislative inquiry under Resolve 55, Acts of 1911, at the hands of the tax commissioner of the state, appears to be based on the mistaken ideas, 1. That there is a corporate usurpation in all so-called voluntary associations whose beneficial interests are divided. 19. Into transferable certificates of participation or shares, and, 2. That because the state feels bound to furnish information as to its impersonal generally transitory corporations, to which it gives franchises, and to regulate those that are clothed with a public interest, therefore it must furnish similar information as to private persons to whom it gives no franchises and which they do not need, and must regulate private interests even when not clothed with a public character. If such regulative or inquisitorial laws are to be valid they should be uniform. Gleason v. McKay, 134 Massachusetts, 419, 425-6, applying to all without discrimination, and should include also all partnerships, for such may issue transferable shares representing millions of dollars. But constitutional provisions that prohibit unreasonable interference with private rights cannot be ignored. The proper appellation for declarations of trust that recognize common law rights in matters of administration, and that restore the personal equation which state corporations evade, is express trusts, the laws in regard to which are well established. No such declaration of trust should employ that all-inclusive, unfit term voluntary association. Trustees under express trusts are not agents, but principals, having the full title and control, and the beneficiaries thereunder are neither partners nor agents. This is elementary. If some authorities are wanted thereon, the following are to the point. Mayo v. Moore at 11, 151 Massachusetts 481, 484. Mason v. Pomeroy, 151 Massachusetts 164, 7 LRA 771. Johnson v. Lewis, 6 Federal Republic 27, 28. Taylor v. Davis, 110 U.S. 330, 334-5, 28 L. ed. 163, 165. Lackett v. Rumbaugh, 45 Federal Republic 23, 29. Smith v. Anderson, L.R. 15, CHD, 247, 275-6, 284-5. The above ruling cases are readily distinguished from the familiar class that ascribe a partnership character to Sir. 20. Tain joint stock companies, associations, and admitted to be co-partnerships, of which Taft v. Ward, 106 Massachusetts 518, and Phillips v. Blatchford, 137 Massachusetts, p. 510, are types. The late Mr. J. Edward Simmons, president of the New York Chamber of Commerce, and for 22 years president of the Fourth National Bank in New York, in his address on October 5, 1905, before the Maryland Bankers Association, on honesty is the best policy, forcibly emphasized the basic principle involved herein. According to the New York Daily Tribune of October 7, 1905, he laid his finger on the real trouble when he declared that the most demoralizing force in business today is the divestiture of personal honor and personal responsibility allowed by modern methods. The extension of the principle of incorporation has enabled leaders in business to set up two standards of morality, to maintain a Jekyll and Hyde duality, and to do as members of an impersonal and non-moral corporate body acts which they would shrink from as individuals. What is wanted, if we are to preserve rigid standards of honesty in business dealings, is adherence to the old notion of personal responsibility and personal integrity. Men, said Mr. Simmons, who pose as the salt of the earth and who condemn, without reserve, those who steal $50, or forge a check for $100, or accept a bribe, will themselves make millions by lying, by fraud, and by bribery. In private life they are stainless, but in the interests of corporations, of the trusts, of the gas company, of the railroad company, of the insurance company they will have recourse to every villainy damned in the Decalogue. The Honorable Woodrow Wilson, in his address at Chattanooga, echoed the distinguished New York banker, Mr. Simmons, and it behooves Massachusetts, now advancing to restore that personality in administration which is the basis of liberty and of sound finance, not to embarrass that movement which finds an efficient bulwark in express trusts but to consider legislation that will implant more vitality at the inception of its impersonal corporate creations, and thus protect these artificial entities from premature oblivion. Express trusts. Corporations. Voluntary associations. Second paper, December 6, 1911. The public hearings given under Resolve, ch. 55, Acts of 1911, have emphasized some common errors. First, that corporations are supposed to bestow numerous PNV1 legs. Whereas for the most part they merely recognize and adopt certain natural common law rights that are not corporate prerogatives or privileges. Second, that corporations present the highest model for organized capital. Whereas of the three standards of administration offered by 1. Corporations, 2. Partnerships, and 3. Express trusts, that of corporations is the lowest, while that of express trusts is the highest. Third, that express trusts are partnerships. Whereas the law of partnerships is a branch of the law of principal and agent, while trustees under an express trust are the absolute principals, but accounting to the beneficiaries, who have no powers either as principals or agents in actual administration. This distinction is clear and indisputable. Fourth, that prohibitive or repressive or regulative legislation as to common law modes of administration can be partial or unequal. Whereas inequality in that respect creates a constitutional conflict. 22. First, that corporations are supposed to bestow numerous privileges. Whereas for the most part they merely recognize and adopt certain natural common law rights that are not corporate prerogatives or privileges. Corporations, as a rule, bestow nothing save the artificial entity that merges natural persons into an artificial being, with the right to sue and to be sued in a corporate name, and as the state creates these fictitious beings, it feels bound to regulate them in some degree. Whatever else most corporations possess beyond their artificial entity and right of suit in their respective names, are mere consequences or incidents of incorporation rather than primary constituents. Waltz Polycon Con. p. 126. Such as issuing transponderable shares, or limiting liability, or using a seal, or making bylaws, or purchasing lands and chattels, these being merely a recognition and adoption of natural common law rights that any person or persons sui juris may exercise without a charter. See Warner v. Beers, 23 Wendell, pages 103, 116, 130, 145-151, 174-176. Waltz Polycon Con, p. 296. There are several very useful and beneficial accessory powers or attributes, very often accompanying corporate privileges, especially in moneyed corporations, which, in the existing state of our law, as modified by statutes, are more prominent in the public eye, and perhaps sometimes in the view of our courts and legislatures, than those which are essential to the being of a corporation. Such added powers, however valuable, are merely accessory. They do not in themselves alone confirm a corporate character, and may be enjoyed by unincorporated individuals. Such a power is the transferability of shares. Such, too, is the limited responsibility. So, too, the convenience of holding real estate for the common purposes, exempt from the legal inconvenience of joint tenancy or tenancy in common. Again, there is the Continuance of the joint property for the benefit and preservation of the common fund, indissoluble by the death or legal disability of any partner. Every one of these attributes or powers, though commonly falling within our notions of a moneyed corporation, is quite unessential to the legality of a corporation, may be found where there is no pretense of a body corporate, nor will they make one if all were combined, without the presence of the essential quality of legal individuality, etc., per Senator Verplanck, in Warner v. Beers 23 Wend. 103, 145-6, et. Sec. 23. The court in that case, pages 149 to 155, refers to several trusts, and unincorporated associations, having the right to employ such accessories, one of the more prominent being that of the Merchants Bank, in the city of New York, with limited liability, as well as transferable shares, the articles of association for which were drawn by Alexander Hamilton. Hamilton's Works, Congressional ed. 7. 838. The most peculiar and the strictly essential characteristic of a corporate body, which makes it to be such, and not some other thing in legal contemplation, is the merging of the individuals composing the aggregate body into one distinct, artificial individual existence. Now this is not found in the associations under the Act. ID 23 Wend P 155. By our common law as it would exist now, independently of statutory restrictions, associations might be formed and trusts created, having every one of the above enumerated characteristics, which have been insisted on as essential to a corporation, except that personality forming its strict and necessary essential legal definition. ID 23 Wend pages 152-3. See also 174-6. In the opinion of the Justices of the Supreme Judicial Court of Massachusetts given to the state legislature, in 1908, on the taxation of transfers of stock, is the following. None of these statutes implies that an excise tax may be laid upon a company, association, or partnership engaged in a simple business, like husbandry, merely because the members agree among themselves that their ownership shall be represented by transferable certificates of shares. Such an arrangement between two or more associates is a simple contract which they have a right to make, and which gives them no franchise or privilege from the government. Such an arrangement does not distinguish them in any way that the state can recognize and make the foundation of an excise tax. This was expressly decided in Gleason v. McKay, 134 Massachusetts 419. Opinion of the Justices in 196 Massachusetts 603, 627. The above applies to the great generality of corporations. The right of eminent domain given to some public service Com 13 entities and to municipal corporations, and certain rights as to transportation, banking, insurance, etc., are special privileges for which multitudes of corporations, partnerships, and express trusts have no need, and give as little cause, therefore, either for prohibition or for special legislative control. 24. Second. That corporations present the highest model for organized capital. Whereas of the three standards of administration offered by 1. Corporations, 2. Partnerships, and 3. Express trusts, that of corporations is the lowest, while that of express trusts is the highest. The frauds for which abuse of state legislation creating artificial beings, called corporations, is responsible surpass all means of ascertaining. They have become a national scandal. It is the restoration of personal responsibility that statesmen, economists, and the wisest legislators are now demanding. One of the oldest, and unquestionably the highest and most efficient administrative method known is that through trustees. No higher standards of administrative conduct are evoked by courts than those which trusts require. To attempt now to prohibit express trusts, or to bring them to the level of corporations or impair their established common law freedom and utility by unnecessary visitorial exactions, is such a blunder, that its manifestation must be attributed to an oversight. Not only are the principles of law and equity well established in their application to express trusts, but they have been successfully adopted for generations quite independently of modern corporations, and in Massachusetts they are applied to property valued at hundreds of millions of dollars, with increasing approval among as able and conservative business and professional men as are to be found in New England. If there have been efforts by any state department to discourage the application of these sound principles, and the maintenance of that personality in affairs which corporations are designedly organized to suppress, they are to be regretted. 25. The doctrine of reimbursement to trustees, and that of a limited liability between trustees and contracting parties, are as much in harmony with public policy, and are as fundamental and well established as any doctrines under which fiduciaries perform their duties, and in point of seniority outrank later-day limited liability partnership statutes and limited liability corporation statutes, which public policy accepts, such statutes being a recognition of the common law. It may be safe to affirm that for a single instance of disappointment in the application of these doctrines there could be found thousands of instances where the wisdom of their recognition and employment is manifest. To attempt now by general repressive legislation to interfere with what has been acquiesced in so long, is so well understood, is so useful, and so accordant with public policy, would be an economic error. Our laws in regard to testamentary trusts under wills, and to conveyancing, are in daily force for the welfare of individuals and of the state, but who would subvert their confirmed principles because an occasional defective will or deed appears? Such casual slips can be rectified by themselves. The great current of legitimate procedure in the execution of express trusts should not be embarrassed because of some suspected transgression or misapprehended legal right. 26. Third. That express trusts are partnerships. Whereas the law of partnerships is a branch of the law of principal and agent, while trustees under an express trust are the absolute principals, but accounting to the beneficiaries, who have no powers either as principals or agents in actual administration. This distinction is clear and indisputable. Joint stock companies, as known in England and in some of the United States *, are unknown to the laws of Massachusetts. Ricker v. American Loan and Trust Co., 140 Massachusetts 346, 347-8. Elliott v. Freeman, 220 U.S. 178, 187. Express trusts, whether created under wills, deeds of settlement, assignments for the benefit of creditors, receiverships, or by special declarations of trust, to manage property or carry on business, are neither corporations nor joint stock companies nor partnerships, but they employ a distinct and the highest known method of administration. Although every trust may be said to include a contract, it includes so much more, and the purposes for which the machinery of trusts is employed are of so different a kind, that trusts are distinct in a marked way, not merely from every other species of contract, but from all other contracts. As a genus. Waltz-Pollock on Contracts, p. 231. Debts incurred under express trusts are not the debts of the beneficiaries under the trust, but are the personal debts of the trustees, who are not agents, but are the absolute owners and principals. The trustees have to account, of course, to the beneficiaries, but the beneficiaries have no partnership powers, and a strict express trust cannot be held as to its beneficiaries to be a partnership, with partnership powers and liabilities, without creating confusion and a mischievous subversion of established principles. * New York, New Jersey, Pennsylvania, Virginia, Ohio, and Michigan. 27. The issue or transfer of a share in a joint stock company makes the new holder a partner, and a party therefore to all contracts made by the company. In the case of a trust, the certificate holder is not a partner or a party to any contract of the trustees. Parsons on Partnership, 449, 4th ed. To my mind the distinction between a director and a trustee is an essential distinction undate on the very nature of things. A trustee is a man who is the owner of the property, and deals with it as principal, as owner, and as master, subject only to an equitable obligation to account to some persons to whom he stands in the relation of trustee, and who are his cestui qui trust. The office of director is that of a paid servant of the company. A director never enters into a contract for himself, but he enters into contracts for his principal, that is, for the company of whom he is a director and for whom he is acting. He cannot sue on such contracts nor be sued on them unless he exceeds his authority. That seems to me to be the broad distinction between trustees and directors. Per James, L.J., in Smith v. Anderson, L.R. 15, CHD 247, 275-6. A trustee is not an agent. An agent represents and acts for his principal, who may be either a natural or artificial person. A trustee may be defined generally as a person in whom some estate, interest, or power in or affecting property is vested for the benefit of another. When an agent contracts in the name of his principal, the principal contracts and is bound, but the agent is not. When you trustee contracts as such unless he is BFLUND, no one is BFLUND, for he has no principal. The trust estate cannot promise. The contract is, therefore, the personal undertaking of the trustee. If a trustee, contracting for the benefit of a trust, wants to protect himself from individual liability on the contract, he must stipulate that he is not to be personally responsible, but that the other party is to look solely to the trust estate. Per Mr. Justice Woods in Taylor v. Davis, 110 U.S. 330, 334, 335, 28 L. ed. 163, 165. Lackett v. Rumbaugh, 45 Federal Republic 23, 29. There is no analogy between an instrument which establishes an agency and one which creates a trust. Where an agency exists, the principal may at any moment interfere, and at all times he is, in legal contemplation, in control of the business. Not so when a party has parted with the title to bis property, and has created a trust which vests in such trustee the right to manage the business as the proprietor thereof, he being accountable to the beneficiary, not as his principal, but as a mere cestui que trust, under the terms of the trust instrument. Per Corliss, C.H.J., in Wellstone Mercantile Co. v. Grover, 7 N.D. 460, 474, 41 L.R.A. 252, 257. The literature upon this subject reveals that inattention, in this important matter, to the distinction in corporate powers between bestowing certain special RGHTS and merely recognizing and employing certain natural common law rights, has at times tended to a misapprehension, intensified by the 28. Added mistake of regarding the relation between trustee and beneficiary as identical with that between principal and agent. But keeping the proper distinctions in view, the class of Massachusetts cases that have recognized as part-on_heirship certain joint stock companies, certain admitted to be associations and admitted to be co-partnerships, such as Phillips v. Blatchford, 137 Massachusetts 510, are readily distinguished from strict express trusts. That express trusts are not necessarily partnerships was unanimously decided by our Supreme Judicial Court, through Mr. Justice Charles Allen, in Mayo v. Moritz, 151 Massachusetts 481, 484, when he wrote that the deed of trust does not have the effect to make the scrip holders partners. It does not contemplate the carrying on of a partnership business upon the joint account of the grantor and the scrip holders, and in this respect the case is unlike Gleason v. McKay, 134 Massachusetts 419, and Phillips v. Blatchford, 137 Massachusetts 510. The scrip holders are cestui qui trust, and are entitled to their share of the avails of the property when the same is sold. See also Mason v. Pomeroy, 151 Massachusetts 164. Mills Inn, Berkshire County, Massachusetts, managed by trustees. Everett v. Drew, 129 Massachusetts 150, 151. Johnson v. Lewis, 6 Federal Republic 27, 28. Smith v. Anderson, LR 15 CHD 247, 275-6, 284-5. Cox v. Hickman, 9 CBNS 47, 98-9, 8 H of L cases, 268, M1 Wellstone Mercantile Co. v. Grover, 7 ND 460, 41 LRA 252. In the case of the Municipal Trust of London, with a capital of £350,000, for the purpose of purchasing bonds of municipalities within the United States, and which came before the U.S. Circuit Court, it was held that, the trust was not a corporation or joint stock company or partnership, but trust, formed by deed of settlement for the purpose of securing investments. The trustees were the legal owners of the trust property, and the business of the trust was managed by them and the committee created by the deed for the benefit of the certificate holders, who were 29. Strangers to each other, and who entered into no contract between themselves, nor with any trustee on behalf of each other, and were not, their/or, partners. Per Caldwell, D.J., in Johnson v. Lewis et.al., 6 Federal Rep. A/. So when assignments for the benefit of creditors are made, or a receiver is appointed, or the National Bankrupt Act is applied, putting the debtor's property into the exclusive control of assignees or trustees, who may conduct the business, Bank Act, 1898, 2, 5, Massachusetts Reverend Laws, ch. 163, Sector 64, Acts of 1910, ch. 141, the beneficiaries or creditors do not become partners. Nor does a trustee's exercise of the common law right to issue certificates of beneficial interest alter the legal status of the parties, or borrow any corporate privilege. A leading case on this is found in Wellstone Mercantile Co. v. Grover, 7 North Dakota, 460, 41 LRA 252, wherein 2 Massachusetts cases, Gleason v. MCK, 134 Massachusetts 419, and Phillips v. Blatchford, 137 Massachusetts 510, were cited by the losing party to maintain that beneficiaries under a trust were partners, but the court through Chief Justice Corliss, in a strong, comprehensive opinion, determined that the relation created by the instrument of assignment which authorized the operation and management of the business, was that of trustee and beneficiary and not that of principal and agent, and hence that the beneficiaries were not partners. The Chief Justice relied, among many others, upon the Massachusetts cases of Mayo v. Moritz, 151 Massachusetts 481, and Mason v. Pomeroy, 151 Massachusetts 164. Strong reliance was also placed by the court on the leading English case of Cox v. Hickman, 9 CBNS 47, 8 H of L cases, 268, where after various appeals the law lords, Lord Chancellor Campbell and Lords Brougham, Cranworth, Wensleydale, and Chelmsford, were unanimous that no partnership arose in the case of property placed in the hands of trustees to manage for beneficiaries. 30. While the law as to trustees and beneficiaries is not a branch of the law of principal and agent, yet just the reverse is the case as to partnerships, for the law as to partnerships is undoubtedly a branch of the law of principal and agent, and it would tend to simplify and make more easy of solution the questions which arise on this subject, if this true PRL and SIPL were more constantly kept in view. Mr. Justice Story lays it down in the first section of his work on partnership. He says, every partner is an agent of the partnership, and his rights, powers, duties, and obligations are in many respects governed by the same rules and principles as those of an agent. A partner, indeed, virtually embraces the character both of principal and agent, per Lord Wensleydale, in Cox v. Hickman, 9 CBNS 47, 98-9, 8 H of L cases, 268, 312. This case is now generally adopted in the United States. George on partnership, 37, 43. True partnership results from the intention of the parties. Gilmore on parton, p. 10, 1911. The rule which made the sharing of profits a test of partnerships rather than a test of intention to form a partnership was overthrown in England, and was never generally accepted in the United States. Gilmore on parton, p. 19. A true partnership is always formed by virtue of a contract between all the parties, and never by operation of law. Shoemaker's Law of Parton, p. 4. Under the modern doctrine of partnership, persons are not liable to third persons as partners, although they share profits, unless a. They are really partners inter se or b. Have held themselves out as partners under such circumstances as to stop them from denying it. Shoemaker's Law of Parton, p. 16. The intention of the parties, as gathered from a construction of the contract they have made, is the real test of the existence of a partnership. Shoemaker's Law of Parton, p. 21. See also the elaborate footnote to Miller v. Simpson, 107 Virginia 476, in 18 LRA, NS. 963 to 1106, and especially Article 13 therein, on the passing of the Old and advent of the New Test of Partnership, p. 1066 ETSEQ, also Article 14 therein on the Agency Test, p. 1072, and Article XXVI, the conclusion, p. 1105. Partners, therefore, are both principals and agents, as manifested by the intention of the parties under their contract. Beneficiaries under strict express trusts cannot be. 31. Partners, because they can be neither principals nor agents, the trustees being the absolute principals, but bound to account to the beneficiaries as sestuique trustant. Everett v. Drew, 129 Massachusetts 150, 151. Mayo v. Moritz, 151 Massachusetts 481, 484. That individuals, or executors and administrators, or assignees and receivers, or partners under articles of copartnership or under statutes as to limited partnerships, and a fortiori trustees under a will or under a deed of settlement or under an express trust, may lawfully limit their liability, accords with established doctrines of restriction by agreement or of stipulations limiting liability. Taylor v. Davis, 110 U.S. 330, 334-5, 28 L. ed. 163, 165. AM&E and GNSIC Laws 22, pages 142, 173. Executors and administrators are regarded in almost every respect, in courts of equity, as trustees. Werner on Administration, pages 10, 798, 1117. Their title, however, in the estate of the deceased is in autre droit merely, id. p. 386, 207 Massachusetts 6, 10, but the title held by trustees under an express trust is absolute in the trustees. It is incorrect to say that because stockholders in corporations are accorded certain exemptions from liability, that therefore trustees, partners, and others who employ the common law right of limiting liability, are imitating corporations, or arrogating some of their privileges, for it is the corporations that are allowed to imitate or to recognize and employ just what individuals and trustees and partners have a natural common law right to do, and have been doing for an indefinite period, without borrowing any later-day corporate incident. In substantiation of the right of trustees to limit their liability by contract under the common law, the following authorities are conclusive. 32. A trustee can be held personally for material ordered by him for the trust estate, and on contracts made by him in its behalf, unless there be a special agreement to look only to the trust. I. On trusts, 437a and cases. By using appropriate expressions, the trustee can exempt himself altogether from personal liability or limit his liability to the extent of the trust. Trustees Handbook, Loring, pages 28, 77, 78, and cases. 3d ed. 1907. The legal estate is in the trustee, and the equitable estate is in the sestuique trust, but as the trustee holds the estate, although only with the power and for the purpose of managing it, he is bound personally by the contracts he makes as trustee, although designating himself as such, and nothing will discharge him but an express provision, showing clearly that both parties agreed to act upon the responsibility of the funds alone, or of some other responsibility, exclusive of that of the trustee. I. Parsons on Contracts, p. 122. 8th ed. 2 page on Contracts, 990, and many cases. The right of making a contract, whereby those who tender it stipulate not to be bound beyond the amount of some specific pledged fund, must be a natural right growing out of the very nature of contracts. Perverplank, Senator, in Warner v. Beers, 23 Wendell, 103, 151. In dealing with the business world, a trustee cannot escape personal liability unless he lawfully restricts his liability in the contract itself. Of course, the parties may agree that the trustee shall not be held personally on the contract, but that only the trust estate itself shall be chargeable with the debt. In such a case the trustee is not bound, but the fund is. Per Corliss, CHJ, in Wellstone Mercantile Co. v. Grover, 7 ND 460, 463, 464, 41 LRA 252, 253, 254. Bank of Topeka v. Eaton, Jew Federal Republic 8, CC Mass-1900. Chief Justice Knowlton in his opinion M. Hussey v. Arnold, 185 Massachusetts 202, 204, says. Whether the trustees in this case, in dealing with the petitioner, provided against personal liability in accordance with the direction in the agreement, as they might do, see Shoe and Leather NATBK v. Dix, 123 Massachusetts 148, does not appear. If the trustees contracted in the usual way without referring to anything which would limit the liability resulting from an ordinary contract, they are personally liable, etc. Later in this opinion the Chief Justice, however, interjects a dictum as to considerations of public policy in an attempt of this kind to do business without a legal liability of anybody for debts incurred by the trustees. But the Chief Justice appears to disparage, 1. His previous recognition of the common law right to limit liability to the fund or property, 2. The declaratory incorporation. 33. Of that common law principle in limited partnership and incorporation acts, and 3. The everyday successful administration entirely in accord with public policy, under this trustee system, and under common law rights, of property valued at hundreds of millions of dollars. Also, 4. The Chief Justice's reference to the trustees, as agents and trustees, p. 204, appears to overlook the doctrine that trustees are not agents, but principals, and, 5. He appears to slight the equitable relief attainable against the estate held by the trustees, and the settled doctrine of equitable execution upon the trustees' right of exoneration, as determined in the case of Mason v. Pomeroy, 151 Massachusetts 164. 167, recognized also in Mayo v. Moritz, 151 Massachusetts 481, 484-5, in Oddfellows Hall Association v. McAllister, 153 Massachusetts 292, 297, and in Broadway NATBK v. Wood, 165 Massachusetts 312, 316. See also, Hewitt v. Phelps, 105 U.S. 393, 426 L. ed. 1072. Stories EQ 11. 978 N, C, and cases. Wellstone Mercantile Co. v. Grover, 7 ND 460, 41 LRA 252. And cases cited. Brown v. Eastern Slate Co., 134 Massachusetts 590. Norton v. Phelps, 54 Miss 467, S.C. Ames Cases on Trusts, 420. 2D ed., and cases cited. Liability of trust estates for contracts made for their benefit. 15 A.M. Law Revelation 449-462. Undisclosed Principle. By James Barr Ames, in Yale Law Journal. May, 1909, pages 450, 451. Bank of 1 OPEC of E. Eden, 100 Federal Republic 8, C.C. Mass-1900. Parsons on Partnership, 447, and Cases, 4th ed. Underhill on Trusts and Trustees, 347, 348, 6th ENG ed. 34. 4th. That prohibitive or repressive or regulative legislation as to common law modes of administration can be partial or unequal. Whereas inequality in that respect creates a constitutional conflict. Prohibitive, repressive, or regulating laws should be uniform, and if any attempt is made to select trustees who issue transferable certificates under express trusts and to omit trustees who do not issue such certificates, or to select partners who issue transferable shares and to omit partners who do not issue such shares, or to select trustees and to omit partners, the constitutional point of inequality is likely to arise, as in Gleason v. McKay, 134 Massachusetts 419, 425-6, which case set aside as unconstitutional the Act of 1878, Chap 275, to tax companies, co-partnerships, and other associations, in which the beneficial interest is held in shares, which are assignable, etc., for as Chief Justice Field said, in Minot v. Winthrop, 162 Massachusetts 113, 122, and quoted with approval by Chief Justice Knowlton and others in the opinion of the Justices in 196 Massachusetts 603, 628. As the tax considered in Gleason v. McKay was not upon a business or employment, and as there was no franchise or privilege conferred by the legislature, the distinction between partnerships with transferable shares and those without rendered the tax unequal and unreasonable, because it was a discrimination founded upon an immaterial fact. Everyone has a right to demand that he be governed by general rules, and a special statute which, without his consent, singles his case out as one to be regulated by a different law from that which is applied in all similar cases, would not be legitimate legislation, and would be such an arbitrary mandate as is not within the province of free governments. Equality of rights, privileges, and capacities unquestionably should be the aim of the law. The state, it is to be presumed, has no favors to bestow, and designs to inflict no arbitrary deprivation of rights. Cooley's Constant Limitations, pages 559, 562, 563, 7th ed. 35. The stampede to organize under corporation laws, and thus try in many cases to obtain something for nothing, by evading personal responsibility, has been perverted into a national disgrace, as the Honorable Woodrow Wilson so forcibly presented to the legal profession in his address at Chattanooga in 1910. It is the duty of that profession and of the legislator p. If any legislation is really necessary upon this score, rather to confirm the common law natural right of all persons sui juris to manage affairs, whether as individuals, or as partners, or as assignees, or trustees under express trusts, as they now do, than to encourage the use of evasive corporate charters. In the great majority of cases administration through express trusts is superior to that of any other method. Mortality in Massachusetts for human beings has averaged during the past 5 years about 16% for every 1,000 persons. Mortality for corporate beings with Massachusetts imprimatur has averaged for the same period about 64%. Express trusts are constitutionally far more healthy. Corporate impersonality in AD administration invites both fraud and disaster. Trust personality is the strongest safeguard against them. Warning, empty page. Express trusts under the common law. By Alfred D. Chandler, ESQ. Supplement. June 15, 1912. The legislature of Massachusetts during its session of 1912 has acted upon the report of the State Tax Commissioner, made under Chapter 55, of the Resolves of 1911, requiring him to investigate and report upon voluntary associations, with a view to their prohibition or further control and regulation, and 2 new laws have resulted, neither of which prohibit express trusts or voluntary associations. 1 law, Chap 595, Acts of 1912, authorizes corporations to be formed in Massachusetts to acquire, manage, and sell real estate, for a term not to exceed 50 years. The other law, Chap 113, of the Resolves of 1912, provides for a commission to investigate the holdings of voluntary associations and certain corporations and the consolidation of companies controlled by them, such investigation being specifically directed to certain public utility companies. The commission is to be composed of the Attorney General, the Board of Railroad Commissioners, the Board of Gas and Electric Light Commission, 2 members of the Senate, and 4 members of the House of Representatives, and it is to report to the next General Court not later than January 5, 1913. Otherwise express trusts whether for the administration of real estate or for industrial or commercial uses are not affected. Continued dissolution of Massachusetts corporations. On pages 10 and 11 of Express Trusts under the common law, the excessive mortality in conservative Massachusetts of its state corporate charters is presented, showing that in 5 years prior to 1912 Massachusetts corporations to the number of 4,154 were dissolved, or about 64% of the whole number created in that period. The Massachusetts legislature of 1912 has continued this elimination by dissolving 929 more of that state's corporate creations, a copy of the act being here printed in full as impressive proof of the illusion and instability of impersonal corporate bodies even in a conservative state. What the death rate of corporations is in other states is not known, but the Boston News Bureau for December 4, 1911, affirmed that in California about 4,000 corporations will dissolve on November 30, because of their failure to pay the required license tax, and in Missouri about 4,000 more are liable to dissolution because of their failure to file the annual antitrust statement required by the state law. The corporate form of ownership is much less prevalent there, west and south, and in consequence, dependence upon corporations is less general, and toleration of their methods is less in evidence. Laws of Massachusetts, Chapter 313, Acts of 1912. An Act. To dissolve certain corporations. Be it enacted, etc., as follows. Section 1. Such of the following named corporations as are not already legally dissolved are hereby dissolved, subject to the provisions of SEC. Sections 52 and 53 of Chapter 437 of the Acts of the Year. This has been a production by the Mental Chemist, for study and education. Copyright 2024.